We're going to NBA Top Shots. We haven't spoken about them in a while. They could be securities according to a federal judge. So this ruling is on a motion to dismiss that comes over a year after a class action lawsuit was filed against Dapper Labs and its CEO, Roham Gargaloo, in New York. The suit claims that both parties violated federal securities laws by offering the NFT collection. District Judge Victor Marrero said the court finds the plaintiff's allegations render each considering under Howie facially plausible. I think I may have missed a word there, but we get it. Dapper filed the motion to dismiss in September, saying that their collection of digital basketball cards are not securities. Adam, I'm going to toss this one off to you. We have two arguments here. We have the judge saying this actually ticks all four boxes of the Howie test. And then we have Dapper saying these are digital basketball cards and digital cards are not securities. What do you make of this?
Yeah, so I'm not a lawyer. I suspect that everybody has the same take right now because it's one that's been pretty common going around. My understanding of this particular ruling is that actually this was the judge choosing not to just dismiss the case. And so as part of that, he's saying that on its face, yes, in fact, these could be securities. That doesn't mean he's finding that they are securities. And that wasn't even really the question that was at work there. The question was, can this lawsuit go forward? And the answer was yes, this lawsuit can go forward. And so at court, we may get some answers or may get some type of indication in terms of what this will wind up being determined. But that is, in fact, the question that will go to trial is, are these things securities? If they are securities, then Dapper's going to find itself in trouble. If they're not, then there's really no case to be had there. Kicking it over to you, Zach.
I mean, wait, aren't they kind of like talking past each other here? Because like the allegation, as far as I can tell from the story, is that the Flow token, the native token of the Flow blockchain, which in turn supports applications like NBA Top Shot, the Flow thing is the securities thing. So that to me, I guess maybe more arguable than the NFT part, but I could be misinterpreting what is at stake here. But the two statements seem to be like apples and oranges. Like the judge is like, well, here's the Flow token, blah, 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 blah. And then the Dapper lawyers are like, basketball cards aren't securities, which is like, yeah, that's probably defensible. But like, so anyway, I just wanted to clarify if these folks are on the same page, if we're talking about the NFTs themselves, or if we're just talking about Flow. Jan, I'll toss it to you.
Yeah, so that's what's kind of unclear in the story. They are talking about the Moments collection, but the Flow token gets roped into the back and forth because the utility token is used in transactions. And so they're saying that like the two kind of work together. Adam, I'll pass it back to you. I don't know if you can explain that a little bit better than I am.
Well, so no, I think you did a great job of that. Just the one piece of context that I would provide is that a year and a half ago, 2 years ago, can't remember. Anyways, during the last bull market, I actually tried to buy some Flow tokens because I was quite interested in that project because the NBA thing was a big deal to me. And I was not able to as a US citizen. So even if they are considered a security, there's lots of extenuating factors where they actually took proactive steps to prevent people from buying them in the US, which would then mean that there is no actual jurisdiction here unless they can find victims. So I think that we are talking specifically about the Moments. And I think that the reason why they're being put forward as securities is because they're making an argument that they passed the Howie test, right? That they actually constituted an investment contract. And so once you've got that, then suddenly there's a case to be had there. But if you can't make the argument that these are securities and instead you're arguing that, hey, I bought baseball cards from someone and I want my money back, well, that's a much worse case that you're probably going to lose.